Court is now in session. Calling case 251403576, State of Utah versus Tyler James Robinson. Counsel, would you please enter your appearances?
Your Honor, Christopher Ballard on behalf of the state. Also here is Jeff Gray, the Utah County Attorney, Chad Grunender, David Sturgill, Ryan McBride, and Lauren Hunt, also all representing the state. And then also Mr. Ben Van Noy from the Utah County Attorney's Office. He's representing the Utah County Sheriff's Office.
Thank you. Good afternoon to you all.
Good afternoon, Your Honor. Kathy Nestor, Richard Novak, and Stacy Visser here on behalf of Mr. Robinson, who's seated to my left.
Thank you. Good afternoon. Mr. Robinson, good afternoon to you as well. All right, counsel. We have a few matters to deal with. I appreciate your ability to make yourselves available. I wanted to, after receiving the motions, I wanted to have a hearing in order for all sides to fully vet out. And it's my anticipation, and I'm not sure if we've confirmed, but I plan to make an oral ruling on Monday at 1 o'clock. I wanted to take the weekend to consider the arguments, re-review all the memos, all the filings, and put that together. So I appreciate your patience for that. I really want to give these important issues as much time as needed in order to make a good decision. With that, counsel, how would we like to proceed? For defense, you filed the original motion, and so I want to make sure that we pick a path that is organized and it's easy to follow for all sides.
Thank you, Your Honor. Richard Novak for Mr. Robinson. And there are sort of some related, partially briefed, fully briefed issues that relate to the primary motion, which relates to shackling. The first thing we did want to ask the court to do is to direct the sheriffs to make one of our client's hands available, so he can take notes during the hearing. We provided him with paper and a pen. And I can tell the court that after spending 2 hours in a room with Mr. Robinson today, I can't imagine any reason why he can't take notes during this hearing, and there's no reason why that would jeopardize his safety or the safety of anybody else. So we think to start the hearing, we need to at least begin with a minimal level of unshackling. And he's not able to write or take notes during what we anticipate could be an extended hearing. And we'd like him to be able to do so. It's a sealed hearing. The public's not here. So we just can't imagine any specific reason why he can't have one of his hands free for writing.
All right. The state? Do you wish to be heard on this issue?
Yes. Ben Van Noy, Utah County Attorney's Office. Given the substance of his motion, I would object on the sheriff's behalf. This is the heart of what we're trying to decide. This is a pretrial proceeding, but we would request that that be denied, as it should be in all pretrial hearings. Thank you.
Any further input?
No, Your Honor.
All right. Is there a way to unshackle one hand for him to be able to write that doesn't compromise the rest of? All right. Let's go ahead and proceed with that.
Thank you. And Your Honor, while we're waiting, I don't care if this is on the record. I have a really bad sore throat. So if I put something in my mouth, it's not gum and it's not candy. Okay? But if anybody wants a Ricola, I'm happy to share them.
All right.
Thank you.
Depends on the flavor.
It's original.
Okay. Some of them are nasty.
No. I don't like any of that stuff.
All right. And before we begin, I just want to make sure that we're all on the same page on the issues that we are addressing today. Mr. Novak, if you wouldn't mind just touching on the topics that you anticipate presenting, and I want to make sure that we're all in sync with what's being presented from both sides.
Agreed, Your Honor. And I appreciate the invitation to sort of do the roadmap. So on Mr. Robinson's behalf, we filed a motion to permit him to appear in civilian clothing and without restraints at all hearings. That motion is fully briefed, and we understand that's the primary reason why we're here today. Obviously, the court knows that we interpreted part of the state's opposition as a motion to actually limit the types of appearances at which Mr. Robinson would appear in person. And we treated that, even though it wasn't designated as a motion, and we filed an opposition to that. The state has not filed a reply. I don't know if that's just because of timing or if the state doesn't intend to file a reply. So that may be a question for counsel for the state. But we also filed a motion to strike the state's opposition to our primary motion because we believe it is impermissibly a pleading filed by a non-party. The motion to strike is fully briefed. And, in fact, Ms. Nestor is going to argue the motion to strike if the court is prepared to hear arguments on that. So I can go a little further down the road of what other issues we think are connected with these. And also, just so the court knows, counsel for the parties met before the hearing about I think one other motion that is partially briefed and some other motions that the parties plan to file in the near future. And we actually wanted to talk to the court about our proposed sort of briefing schedule for that, and when we might have a hearing depending on the court schedule. So it's not super linear, right? There's a little bit of complexity there.
Sure.
Do you want me to mention the other slightly related motions now? Or do you want to deal with that later?
Let's do that so it's all out there and we can see the trajectory of where we're going.
Okay. So I think the two issues that relate most squarely to our primary motion to appear in civilian clothing and without restraints are, 1, a motion that we intend to file on behalf of Mr. Robinson to completely eliminate all video and audio broadcasting or delayed feeds of court proceedings. And we haven't briefed it. We're not going to argue it today unless the court decides it wants to hear preliminary arguments. But the parties have discussed the fact that we are going to bring that motion. And I think that we will bring that motion regardless of the ruling of the court on Monday on the shackling/civilian clothing issue. Okay? So that's one. The second is this court's SUA spot pretrial and trial publicity order, which the state has informed us they're going to seek both a modification and clarification of, and we were also, even before we knew that, we're going to move the court to modify it. And the reason why we believe that these are all related to each other is because we, meaning Mr. Robinson and his defense team, are very concerned that the nature, content, scope, pervasiveness of the pretrial publicity of the statements that have already been made by law enforcement officers, by lawyers, by the representatives of the state in this case, may have a significant impact on the fairness of his trial. And so modifying the pretrial publicity order, addressing the cameras in the courtroom, and, frankly, addressing the individualized propriety of shackling in the courtroom all really relate to the fairness of the proceedings. There are two other reasons why shackling we believe is. The current shackling protocol and practice with respect to Mr. Robinson is unconstitutional, but those don't relate directly to the fairness of the proceedings in the traditional sense. There's another motion, which we've also discussed with counsel for the state, and they're well aware that we're going to do this. And this is a motion to actually disqualify the Utah County attorneys from representing the state in the prosecution of this case. If the Utah County attorneys want to represent the sheriff as an entity for security purposes, that's a different issue. We are focused on whether there is a conflict of interest, and we are in a sealed hearing, correct, Your Honor?
Yes.
Okay. So, and I'm not trying to pre-argue the issue, but the Utah County attorneys have advised us that a family member of one of the attorneys was present at the incident at which Mr. Kirk was shot and killed, that this child, I don't know if they're an adult, but I'm not referring to them as a minor. This child was present, observed it, was within 85 feet of Mr. Kirk when he was killed, had to flee, that the Utah County attorney's office was all advised of this, that law enforcement were actually deployed to the area with her safety and status in mind. I am not trying to pre-argue this, Your Honor, and I'm not saying anything that we haven't already discussed a couple times with counsel for the state. So we are going to file a motion to disqualify. And all of these motions, we've already talked about getting them all filed before Thanksgiving. That doesn't mean that we want the court or anybody else to work over the holidays, but there's a lot of work there. And so we need, a few weeks to get that all done. This court may have some preferences for how those motions are triaged, if I may, but those are the things sort of circling around today's motions, and I think I should stop talking here.
All right. And, to the state, I just want to make sure that, from your perspective, that same understanding of what we're addressing today. I just don't want to go down the path and then one side says, wait a second. I thought we weren't going there. I just want everyone to start at that same starting point.
That's perfect, Your Honor. With respect to what's at issue today, we agree it's the motion to strike the state's response, the joint response of the state and sheriff's office, and then also the substantive motion about clothing and restraints. The state did not make an affirmative motion in its response, and so that's why the state has not filed a separate reply. So, and I'll explain that later during my argument. But from the state's perspective, those two motions are fully briefed, ready to go for the court today. As far as the three motions that counsel mentioned, I think that's all the state's understanding as well, that those will be filed. We'll do our best to respond expeditiously. We're very interested in getting a preliminary hearing set in this case as soon as possible. And we anticipate that once we get those motions resolved, or at least argued, then we can move forward with setting a preliminary hearing date. There are two other motions that I think the court should be aware of that are docketed. The court, there is defendant's motion to preserve evidence. That's docket number 75. The court entered a premature order on that motion. That's docket number 107. And the state has filed a motion to set aside that premature order. That's docket 116. And defendant's response to that motion is due in early November. And then, from our perspective, the defendant needs to file a reply to, in support of the motion to preserve evidence.
We may be able to meet and confer on the preservation of evidence and eliminate adversarial litigation about it, because I think, I just think that we may be able to do that. We will try to do that. It's really a question of what evidence needs to be preserved, and what advance notice needs to be given to us before biological evidence can be used even if it might disappear. And so we're going to at least try to meet and confer about that. We may have different definitions of materiality, but we'll do what we can to eliminate things that we maybe can agree upon, and not burden the court with another set of briefing.
All right. I appreciate that. Anything else, Mr. Ballard?
No, Your Honor. Thank you.
So the one concern that I have is, and I appreciate counsel laying this out, is the issue of the media and photographs and video, because this is very ripe, as we have a hearing on the 30th. And so I'm just trying to get an idea of how much time do we need, because as this court's trying to, it's intertwined. And so as I'm looking at what decisions to make, that is an important consideration because it touches upon the issues that we'll be talking about today. And so where are the parties at with that, understanding that we have a hearing on the 30th?
I think where we are at after speaking before we came into the courtroom is we're not, especially since we're here today, we're not sure we actually need a hearing on the 30th.
Okay.
And we've discussed that with Mr. Robinson. He understands the consequences of further delays, so that we can raise these issues and litigate these. I don't want to speak for the state, but I think our idea is given that we need, like I said, before Thanksgiving, to file the motions that we're talking about. Maybe the court wants to suggest a hearing date in early January. We will get all the briefing done in time for that. Or whenever the court is ready to do that after the holidays. And we don't need the status conference. The court set the status conference before any motions were filed, so it makes sense that it's on calendar, but now here we are today. We just don't think that there's a need for a hearing. And we certainly can't file, brief, and represent that it's submitted to your honor before the 30th on any of those.
Okay.
So if the court's comfortable with vacating the hearing on the 30th or postponing it, or however the court wants to fashion the scheduling, that's fine with us. We don't need to be here next week unless the court wants to hear further argument on something that we don't cover today.
All right. And to the state?
And, Your Honor, the state agrees with that approach. We don't think we need, given everything that we've been able to do today and will be able to do today, we don't need that hearing on the 30th.
All right. Well, we can address that at the end of today's hearing. All right. Well, it looks like we'll be addressing the motion to strike and address and restraints issue today. So with that, let's go ahead and move forward.
Ms. Nestor is going to handle the motion to strike. I'm going to sit down. Thank you.
Good afternoon, Your Honor. Kathy Nestor on behalf of Mr. Robinson. May it please the court and counsel. Your Honor, the motion to strike, obviously it's more of a procedural complaint that we have than the substance that Mr. Novak is going to cover with you about the shackling. But we had some concerns in the manner in which the state replied, and I do think there was a little bit of confusion. I think we were all trying really hard, admirably, to get to the court quickly on this issue, because we all recognized this matter needed to be resolved before any additional hearings were held. And we're very grateful to the court for what you've done to get us here quickly. And all the orders you issued trying to accomplish that, we appreciate that very much. And we know that's what was happening. I do think there was a little bit of confusion. The first order that came out by the court, it came out on October 13th. And in that order, in our motion, we made it very clear, and Mr. Novak will get into all the details of this, so I don't want to steal his thunder, but we welcome the participation of the sheriff in this process. We recognize that the sheriff would have important information that the court would need to take into consideration in making findings on our motion, our anti-shackling motion if I'll just call it that. So we had invited that. We expected that. We asked that the court consider whatever documents the sheriff needed to participate with, that they would be looked at on an ex parte basis. We certainly recognize that it might not be judicious for us to see the inner workings of all the jail. We frankly don't want to know any of that. So we had already laid the groundwork in our motion for this information to come from the sheriff. We welcomed it, we wanted it, and we think it's appropriate. We were a little bit surprised when we got the response in that it appeared to us, it is apparent on its face, that the sheriff is entering an appearance as a party with this pleading, that they are actually, through Mr. Van Noy, lodging objections to our motion as a party would. And that just instantly raised some concerns with us. First of all, because we are looking at a very long case. This case is probably going to last a long time, hopefully. And, we're very concerned about right from the get-go a precedent being set where the sheriff can enter appearance in our case, lodge objections to our motions, and appear and, through counsel, to be heard. That we certainly were not inviting that in our motion that we filed, and we felt very strongly compelled to shut that down quickly and permanently. We did cite to the court in our motion. Certainly we recognize the state can and should respond, and that it would be perfectly appropriate for the state to reveal either through exhibits or through testimony at the hearing what the concerns of the sheriffs were. I think that would be proper, and we expected that to occur. The concern we have is that it appears the sheriff is actually entering an appearance as a party. We don't think that's proper. We have cited to the court a couple of cases, the Lane case and also the Brown case where our Supreme Court has dealt with the issue of the fact that there are only two parties in a criminal case. Where this usually comes up in litigation is when victims try to intervene in a matter. It's happened to me. It's happened to other people, I'm sure. I'm sure you will see it as you sit on the bench a little bit longer. But that does happen sometimes where a victim pops in and says, hey, I'm not happy with the way something's going. I want to file a motion. A lawyer tries to file a motion. And in these two cases, that's basically what happened. There were questions of appealability. If something the victim wants is denied, can a victim appeal to appellate court? Those kinds of things were addressed. But both of these cases, while not on point with what's happening here at all, and we acknowledge that, they're certainly analogous. And the Supreme Court made very clear in the quotes that we put in our motion to strike that the proper procedure is that the party does not have a right to enter as a party. They cannot file pleadings. They don't have a right to file an appeal. They have a right to be heard under our victim statute, but there's no similar statute for a sheriff or people concerned about security. And actually, in this case, there's an affidavit that's been attached by Mr. Palmer. He actually is part of the court system that is looking at court security, and his affidavit was attached here. I know he's here outside in case any of us are willing to call him in, but I think he did it the right way. I think his attachment of his affidavit is how that should happen. Right. That he's given you his expert opinion, and the court certainly can take that into consideration. We just felt, I know it's unusual to start right off with trying to strike a plea from the other side, and that's not something we do very often. But we do think that's important because we have a lot of litigation ahead of us. And I think we need to just make it very clear that we have boundaries here and that, while we welcome the sheriff's participation, we want their information to get to you so you can make your decisions about safety and security for our client as well as everyone else. But we strongly object to them appearing as a party. And so I guess our suggestion was if we could strike the pleading to the extent it is on behalf of the sheriff as a party, we would not object to the information the sheriff wants to share with you. We're not trying to shut the sheriff down or say that you shouldn't consider what they have to say. But we are very concerned, and we are asking for that reason that the pleading be stricken and that the court consider it as witness testimony or as evidentiary offerings on behalf of the county attorney, but certainly not accept it as a proper and allowable pleading on behalf of the sheriff as a party. And I believe, anything else I need to add to that? I think I would submit unless Your Honor has any questions for me.
And so my understanding of what you're saying is that the state should be allowed to call them as potential witnesses.
Sure.
They put on the evidence. And then typically in criminal cases, an evidentiary hearing is held and then briefing occurs afterward.
Right.
And so what would be your thoughts if we follow that path and then they file the exact same motion?
Right. Well, we would really like to proceed with a hearing on the shackling motion today, and we're not trying to derail that. I think if we could just have some clear indication from the court that the court is going to treat this pleading not accepting it as a party pleading from the sheriff, but that the court is going to treat this as a pleading from the state and only the state, and that the objections are being made on behalf of the state and is not being made on behalf of the sheriff. I envision some type of order that just makes it very clear that in the future, the sheriff is not invited to file pleadings or objections, but that you will consider the information in the motion as you take this whole matter under consideration. And we actually don't have any objection to that. Does that make sense?
So basically clarifying that the sheriff's department is not a party, but as it relates to the motion itself, it sounds like your position is, and correct me if I'm wrong, that your fine is with the understanding that the sheriff is not a party and cannot file objections.
Right.
Am I understanding that?
Right. Because the motion actually says, the sheriff objects to, blah. The sheriff, like they're lodging objections to our pleading. And I think if we all understand that that's not proper and it can't happen again, but that for expediency purposes, because we all want to have this heard today, that you will take it into consideration as witness information, as evidentiary information, but not as an expression of a party that is entering an appearance and lodging an objection, because we don't think that's provided for under the rules.
And is it your preference today if I were to go down that route that the state calls witnesses to support what's in their motion? Or are you willing to accept it as is, as filed?
I think that's totally up to the state. If they feel that they've sufficiently provided you with the information, that's fine. If they want to call them, that's fine. I don't think we're going to jump in their boat and make that decision for them. But all we're concerned about on the motion to strike is that it's very, very clear that the role of the sheriff is as a witness. Even as an expert, that's fine. But not as a party and not as someone that can enter appearances now or in the future.
All right. Thank you.
Thank you, Your Honor.
Mr. Ballard.
Your Honor, Christopher Ballard on behalf of the state. There's nothing improper about what the state did about the state and the sheriff filing a joint response to the motion. When the court ordered the sheriff to respond, when the motion implicates court security, which is the joint responsibility of the sheriff and the court, and when the state's interests and the sheriff's interests are aligned. And let me just make it clear at the outset, the state is not trying to sneak in the sheriff's participation. The state is not trying to make the sheriff a party or be able to offer his input, the sheriff's office input on anything that is not directly related to the sheriff's responsibilities in this case. The state was simply trying to comply with this court's orders, the first of which ordered the sheriff to respond and then also ordered the state to respond. And both of those orders required the defendant to serve his motion on the sheriff. And so I don't think you can fault the state for doing its best to just try and comply with this court's orders. I think even if there was something improper about the way the state did this procedurally, I think the information, the rules, the authority that we've cited in our opposition to the motion to strike explained that the sheriff does have standing, or persons can have standing as limited purpose parties. Not a broad purpose party or a main party in this case. That's not what we're trying to do. The sheriff or anyone in a case can have limited purpose standing when you've got a rule or a statute that allows that person to either claim a right or to offer input. And as opposing counsel pointed out, this comes up most often in the situation of crime victims, but it's not just limited to crime victims. As we cited in State X Rel. JT, that was a case where you've got a child welfare proceeding. You've got a statute that says that relatives can give input as to placement in those kinds of cases, and so the grandmother had limited purpose party standing to be able to give her input. Here, we've got authority that allows the sheriff to give input on these kinds of decisions, and that's all we were trying to do in accordance with what the court requested. If the court has further questions about limited purpose standing and the reasons for that, Mr. Van Noy can address that on behalf of the sheriff. But that's the state's position unless you have any further questions for me.
Well, perhaps the court can give a little bit of clarification, because there were 2 orders, and what happened was on that day, it was a holiday. The court came in and was reviewing the order, and it wasn't the official order because it was trying to be sent out as a courtesy given the time constraints. The court then issued the order the second day with the removal of requiring the sheriff's response. And so for clarification purposes, that's what happened. The first one was simply a courtesy copy just to be like, all right, we have these tight deadlines, and wanted to put all parties on notice to give them opportunity to prepare given the holiday, but that second order was the actual order that was entered in. The first was not. So for whatever clarification that gives to all parties, that's what happened. But I understand the confusion with that. In regards to the position of Ms. Nestor that the evidence should come in as witness testimony as opposed to as it was brought in today, what is your position?
As long as Your Honor fully considers the information that's in that response, whether it's just as a witness or a limited purpose party, we just want that information before the court because the sheriff is the expert on court security.
And moving forward, what's your position on adopting what has been proposed by Ms. Nestor for future input as opposed to filing a motion, going the route of calling witnesses, and then, based off witness testimony or affidavits, using that to supplement a motion post-witness testimony?
I think that's fine as long as it gives Your Honor the information he needs to be able to make those decisions about security issues.
All right. Thank you, Mr. Ballard.
You're welcome.
Yes. And if you'd like to give a little bit more background on the limited purpose standing of the parties.
Absolutely. Ben Van Noy, County Attorney's Office. The Sheriff's Office wants to make it clear that they are not entering an appearance in this case and they do not intend to ever enter an appearance in this case. The Sheriff's position is that they would be okay if the state's opposition was entered in or if there was an order entered in finding that is an opposition from the state. Like Mr. Ballard just expressed, there was some confusion with the 2 orders. The Sheriff's Office being a non-party didn't have the benefit of not knowing that the first order wasn't entered. We didn't get that notice until it was too late. So, quite simply, the Sheriff's Office was just trying to respond to the court's orders, which wasn't unusual, because the Sheriff's Office gets ordered by the judges all the time to do various things. Orders to transport, orders to allow inmates to have access to the law libraries, stuff that is a part of the criminal case, but not, it is more tangentially related. That's another reason why the sheriff decided it was proper to respond. The Sheriff's Office is a unique participant in criminal cases. Both statute and rule obligate the sheriff to have input in security measures, and the defendant's motion directly implicates those. And the sheriff, to be clear, is less concerned about how those objections are made. They just want to make sure that they have a seat at the table because they want to ensure that the safety and security of this court is paramount. So whatever the court needs to do to clarify that, the sheriff would be okay with that. Whether that's treating them as a witness, their statements as witness statements, we would be okay with that. I think that's all I have from the sheriff. I would submit unless Your Honor has any questions.
No. Thank you. Ms. Nestor, would you like to respond?
Just very briefly, Your Honor. As far as the limited party appearance, it sounds like we're getting close to agreeing to how this should happen in the future, which I appreciate that. But just to make it very clear for the record, that we do not think there is sufficient statutory or administrative authority that would open the door to a limited appearance such as there would be for a grandparent in a custody hearing or for a victim in a restitution hearing. We just don't think that exists here, and we don't see the judicial regulations that are referred to in their opposition that provide that a bailiff, that sheriffs be present and keep us safe in the courtroom. We don't think that opens the door to a limited party appearance of the nature of which was argued in the opposition. But I think that might be moot. But I just wanted to say that for the record, Your Honor.
Thank you. All right. Anything further on this motion to strike?
Your Honor, one more thing if I may.
Yes?
The scenario at hand has the sheriff's office and county attorney's office agreeing. Hypothetically, if the county attorney agrees with the defendant but the sheriff disagrees, we don't know what mechanism we would use to lodge that objection. Utah Code 17-22-21, C, requires the sheriff to obey all lawful orders. In rare circumstances, there are orders issued by the bench that the sheriff's office deems unlawful. In those circumstances, the sheriff's office has filed objections, not as parties, but as an interested party. That is unclear in state law how the sheriff's office is supposed to address that situation. If an order isn't lawful, how does the sheriff's office voice that opinion? That's all I have. Thank you.
Can you give me an example of what has happened in the past that helps the court understand?
Yes. Absolutely. Just a few months ago in a probate case, the mental health of the beneficiary was at stake, was being questioned. The court ordered the sheriff's office to transport this individual to a mental health facility for a mental health evaluation in Salt Lake City. It being a probate, a civil case, the sheriff's office objected because that, in their opinion, was not a lawful order. There was no statute or rule that allowed the court to include the sheriff to transport an individual in a civil case. That matter was never fully ruled upon, but it was an objection that the sheriff's office made as an interested party in that case.
All right. Thank you.
Yep.
Ms. Nestor, and under that scenario, what in your view would be the proper approach if there's a divergence of opinions from the Utah County Attorney's Office and the Utah County Sheriff's Office? How would the sheriff's office be heard on an issue?
Can you give me 1 second to ask someone smarter than myself? Let me ask Ms. Visser really quick. I knew she would know, Your Honor. Thank you. And I think she's right. So under that scenario, when the sheriff has been ordered to do something by the court, that does potentially open the door, I would say, to responding to that order. And I have no idea what type of similar situation would arise in this case, but I would hope that we could all maybe just talk about it and see the proper way to handle it. We don't ever want to concede that the proper way to handle it would be to enter an appearance as a party. I do think there's ways for non-partists to object to orders they get from judges, and we can probably figure that out later. But I honestly can't think of a scenario where that would happen in a case like this. It's never, ever happened to me. So, and I've been doing this quite a while. But I guess there's always the possibility. And if it happens, we'll all confer and see if we can figure that out.
All right. And I just want to make sure. Anything else further on this particular issue?
Yeah, Your Honor. Just let me add. I think for purposes of this motion, it sounds like we're all in agreement that the court can just consider this however it wants to consider it and making it clear that it's not the sheriff entering an appearance or appearing as a party. If there is some issue down the road and we've got an order that requires the sheriff to do something, then that would be a completely different situation than what we've got here.
All right. Thank you to all parties. I will reserve ruling on that issue about the motion to strike until Monday. But for the purposes of this hearing today, and it sounds like there's, as best can be stated, the stipulation that the motion filed, not acknowledging from defense side that the sheriff's office is a party, but it's still accepting the information therein to be considered as we move forward on the other issues.
Yes.
All right. So with that, we'll go ahead and move forward with the issues of appearance and restraints.
Thank you, Your Honor. Richard Novak again, for Mr. Robinson. And the court did say in its introductory remarks that it wants to take the weekend to think through things and review things. So I hope the court will permit me to suggest a couple pieces of case law that the court may want to look at again over the weekend. I think where I want to start, which is where I think we should always start, is with the constitutional law as explained by the Supreme Court of the United States. And I know that the court has read our briefing, but DCK versus Missouri, a 2005 opinion of the United States Supreme Court, guides us here initially. Basically what DEC says is that a blanket policy of shackling a criminal defendant violates the defendant's constitutional rights. And I would say in a capital case, through the 14th Amendment, since we are in state court, that would be the 5th Amendment, the 6th Amendment, and the 8th Amendment. Because what the Constitution requires is an individualized assessment of whether shackling is necessary because of security risks emanating from the defendant. Now, I understand. I'm going to come back to that, but I just want to bookmark, if I may, that I understand that there's a fundamental disagreement between the parties about whether the constitutional framework applies outside of the jury trial. Okay? The most recent Utah Supreme Court case on this is Cravens, CRAVNS, a 2000 decision, which basically gets it wrong in light of the subsequent decision of the United States Supreme Court. Because in Cravens, what the state of Utah Supreme Court said is, the defendant's been found guilty. He can be shackled during the penalty phase. And clearly what the Supreme Court said in DEC versus Missouri is, no, that's not true without an individualized determination. So I will address why we believe that this court, without any guidance from the Utah Supreme Court, is free to, and should make a finding that Mr. Robinson has a constitutional right not to be shackled in pretrial proceedings. But I do want to go back for a moment to the 3 different reasons, as explained by the Supreme Court, why shackling offends are concepts of fairness and liberty and due process. The first is, because these are applicable to a defendant at every stage of the proceeding, the concepts, the rationale. Okay. The first is because there's a presumption of innocence. The second is a concern with the 6th Amendment right to actively participate in his defense in the courtroom. And if the court, if I may, looks back at the rationale of DEC versus Missouri, when it's considering this over the weekend, the court will see that the Supreme Court said that to be shackled in a courtroom necessarily interferes with a defendant's right to thoughtfully observe and participate in the proceedings because the shackling is inherently intrusive in his ability to do so. And then, the third reason is what the High Court referred to as dignity and decorum in the courtroom. Most of the hearings in this case will be public. And so for the public, and I'm not even talking about cameras and microphones, especially cameras, to see Mr. Robinson shackled at the feet, at the waist, at the hands, absent an individualized determination by the court, offends the dignity and decorum of the courtroom. This is not a jail. This is your Honor's courtroom. And what security measures are necessary to ensure everybody's safety, including Mr. Robinson's, are your Honor's decisions, not the sheriff's decisions. So we are not challenging the policy that exists. We're saying that the Constitution requires that this court make an individualized determination as to whether that policy is appropriate in this case. Because it's a constitutional right, it's the state's burden to prove that shackling is necessary. And what Deck v. Missouri says is it's defendant-specific information that suggests that shackling is necessary. So I'm going to provide the court, if I may, with some hypotheticals. If in his first court appearance, Mr. Robinson did anything that suggested a lack of safety to himself, to the court staff, to the sheriffs, that would be information. If Mr. Robinson demonstrated, which he has not, some inability to control his conduct while in custody or while in the courtroom, that would be information that the court should take into consideration. Mr. Robinson's criminal history, which he has none until this incident, would also be something that the court could take into consideration. I think the court could look at a rap sheet or a pretrial services report and say, this person has a history of assaulting law enforcement or fleeing or obstructing justice. Whatever it is, but none of that exists here. And so it's an individualized determination about the defendant, and it's the state's burden of proof. And I want to point out that, two things. One is in the state's opposition to our motion, the state provides nothing specific, nothing individualized, as to why Mr. Robinson needs to be shackled in a courtroom. We are not asking that law enforcement officers not be present. During a jury trial, it may be a very different scenario. But the state has offered no specific evidence that he presents a risk to anybody in the courtroom or to himself by being unshackled. And it is, as I said before, the state's burden. And I'm going to say a couple things because we're under seal, and I think that it's appropriate to take advantage of that. And I appreciate that the court created the freedom to address things that should not necessarily be further publicized in the public sphere beyond what's already been publicized by others. When Mr. Robinson first was arrested, redacted. And I think it's interesting that the sheriff's department hasn't provided the court with any information as to why that is, that he has convinced the sheriff's department that that's not necessary. Now, Mr. Robinson has, as I understand it under state law, a right to privacy and confidentiality with respect to his medical records, his mental health records, his psychiatric records, if any, even those created in custody, and so I am not going to offer up those records, nor would I think the court would interpret what I'm going to say as a waiver, but the sheriff has those records. The state, to make that distinction again in terms of the parties, should not have those records, and that's complicated if they're represented by the same lawyers, or at least their communication with the court is facilitated by the same lawyers. But the sheriff presumably has an obligation to provide the court with all the information that it has available to it to make that individualized determination. We have those records, and we're not afraid of him. So I would just ask the court to consider whether it needs more information from the sheriff to make an individualized determination. So what we are saying is even if this court conducted an evidentiary hearing and conducted an in-camera review, there is no way that this court could reach a conclusion that shackling is necessary based on information directly related to Mr. Robinson. Now, in the state's opposition to our motion, there is a lot of information, and I'll try not to be sarcastic, but I do think it's kind of noise, about the intense public interest in this case. There's a reference to, unstable people coming to the courthouse, to conspiracy theorists saying things online. We're all aware of that. I mean, I don't know what the court has read. It's none of my business. I've received some wacky phone calls and emails, people telling me what they think happened here. It's noise. We're not litigating this case in the press. We're not talking to crazies. But that's all on the outside. So we appreciate that the sheriff's department is concerned with the safety of the court and all of the participants. We were here a few weeks ago, and it was clear that the sheriff's department took the first appearance of counsel very seriously, and we appreciate that. That's not Mr. Robinson. So we don't think that the intense public interest, which may be drawing an unstable fringe people from the left and the right and the center and other places is imputed to Mr. Robinson. The question is, can the court trust Mr. Robinson to sit there the way he has been doing for the last hour and respect the decorum and the dignity of the courtroom, just like the court would expect him to? And we think that the answer is obviously yes. So then, I want to get to the slightly more open question, which is, what would guide this court in determining whether that constitutional right should attach at all proceedings and not just before the jury? And there was a dispute in the pleadings about what I would call the relevance, although not, relevant under the rules of evidence, the relevance of an en banc opinion of the Ninth Circuit after Deck called United States v. Sanchez-Gomez. It's a 2017 en banc decision of the Ninth Circuit. And I apologize if this is obvious to everybody, but I live and I practice in the Ninth Circuit. So basically what that means is there was a 3-judge panel. Somebody didn't like the outcome of a ruling and invited the court to take the matter up en banc, and the court did, which meant that there had to be 18 judges who heard the case. And the citation to that decision is in our briefing, and I'll provide it again. But what the Ninth Circuit says in an en banc ruling, and I'm going to talk about what it means, as the state points out, that ruling was vacated by the Supreme Court. The holding in that case, which is based on a lot of rationale from then Circuit Judge Kaczynski, is that the constitutional rights outlined in Deck versus Missouri apply at all proceedings in a criminal case, not just in a jury trial. And I think that if Your Honor looks closely at the rationale, this court would conclude that the rationale applies at all hearings. That doesn't mean that we abandon the individualized determination of the need. It just means that the individualized determination of the need should begin at the beginning of the case, and not just wait for the jury trial. Sanchez-Gomez is important because it's really the only well-thought-out opinion of a federal circuit court looking at the constitutionality of this question. But the procedural posture of that is what led to the United States Supreme Court to vacate the decision. And so what happened there is in the Southern District of California, which is basically San Diego and Imperial counties, the United States Marshal Service adopted a policy that every defendant would be shackled at every hearing. And the federal judges in the Southern District of California went along with it. They said, "Okay, fine." For defendants sought review of that policy, which was affirmed by 4 district judges in 4 criminal cases, through a writ of mandamus. By the time it got to the Ninth Circuit, and certainly by the time it got in bank, it was what most people would call moot. But what the Ninth Circuit said was, "No, it's not moot. It's capable of repetition, and it's an important issue, and even the Ninth Circuit even referred to it as a quasi-class action." So if the court looks at Sanchez-Gomez, there's a lot of discussion about mandamus review, and whether it meets the criteria of mandamus review, and whether mootness interferes with the court reaching a conclusion. And ultimately the en banc court says, "We're going to resolve the merits of this." Okay? And so what the Ninth Circuit en banc opinion says, written by Judge Kaczynski, is, "Those constitutional rights to be free from shackling absent and individualized determination apply at every hearing, because dignity and decorum isn't limited to a jury trial, because the Sixth Amendment right to participate isn't limited to a jury trial, and because the presumption of innocence exists from the beginning of the case until the return of the verdict." When it went to the Supreme Court said, "It's moot. We're vacating the opinion. It's moot. Those defendants are no longer in court. They're not being shackled." And the Supreme Court also rejected the notion that 4 criminal defendants can get together and create a quasi-class action through a writ of mandamus. But I reviewed the Supreme Court decision again this morning, the one vacating Sanchez-Gomez, and I looked for any hint from the Supreme Court that it was taking issue with the merits, the substantive decision of Judge Kaczynski speaking for the majority of the panel, and there is not a word about it. There's not a footnote. There's not a concurrence. There's nothing. So first of all, we're not in the Ninth Circuit. All right? We're in the 10th Circuit, and we're in Utah. So it doesn't even bind. Even if Sanchez-Gomez were still good law procedurally, it's not binding authority anyway. It's persuasive. And I would suggest it should be very persuasive to this court. But what's important? Because there was a big debate in our pleadings about its relevance, its viability, the rationale as to why the shackling, the right not to be shackled absent an individualized determination of security concerns applies at every hearing is not addressed at all by the Supreme Court. And so that's why the rationale is still worthy of this court's consideration. So what we are asking this court to conclude is that while there is nothing in Utah law that compels a decision either way, Your Honor has the opportunity to make a decision of constitutional law. And it is a decision that needs to be made by the trial court because here we are. So we think that what this court should conclude based on what's in Deck versus Missouri, and the rationale in U.S. versus Sanchez-Gomez is that Mr. Robinson does have a constitutional right not to be shackled at all proceedings other than where the state has made a showing of an individualized risk to the security, to the decorum of the courtroom, emanating from Mr. Robinson. And while we understand that there's a lot of what I call noise, there's noise on the outside. Maybe not. I saw one person with a camera in the lobby today. I don't know. We also got here at 2 o'clock, so maybe there was more. Or maybe nobody was interested because it was going to be a sealed hearing. But none of that affects Mr. Robinson's right to be free from shackling in the courtroom absent this individualized showing. If we need to have an evidentiary hearing about an individualized showing, we can do that. I've already hinted to the court that the sheriff has information, and I don't think it's duplicitous or secretive. I just think that we are saying the court needs to make an individualized determination. The sheriff has information that the court may or not want to review. But it's their burden of proof, and we're not waiving Mr. Robinson's right to protect the confidentiality of his information. We're not trying to run away from it, but we're just not going to lodge it as an exhibit that needs to be shown to the people, to the state, because it's their burden to make that individualized showing of risk. As long as this court permits cameras, whether it's video or still cameras, to broadcast either live or with delay, proceedings in this courtroom, we also believe that Mr. Robinson should be dressed roughly like everybody else, because the entire world has already seen him, because the sheriff's department released a booking photo, and because there were cameras in the first remote appearance in this case. Has already seen him in a jail jumpsuit with a vest on. But if he's going to be in this courtroom, and we're going to have a secure courtroom, but it's going to be broadcast to the world, he should not be depicted as a jail inmate. He should be depicted as a citizen of the United States, with a presumption of innocence. And that is why we believe he should be able to appear in street clothes that also are consistent with the court standards for what kinds of clothing individuals can wear. If he shouldn't have shoelaces, we can get him shoes without laces. If he shouldn't wear a tie and it's a cold, we'll get him a sweater. But unless we're going to shut down all the video and all the photography of what goes on in this courtroom, he shouldn't be wearing jail stripes. So that part of it maybe is wrapped up in another motion that we're going to bring to the court, as we said before. But we do believe that in the absence of that individualized showing, the shackling should end right now. I don't think there's anything more that I want to say unless my colleagues tell me I missed something. And they're shaking their heads in the negative. So with that, I'll sit down and see if there's any need to reply when the state's done. Thank you, Your Honor.
Thank you, Mr. Novak. The state?
Your Honor, I think this motion raises two primary issues. And the first one is, when is defendant's presence necessary at a hearing? And then the second one is, when his presence is necessary, what security measures are necessary because of defendant's presence? And I think of course the overarching question involved in this motion is how best to protect the defendant's presumption of innocence and avoid tainting the jury pool while maintaining the security of everyone involved. And let me make it clear that the state is just as concerned about a fair trial in this case as the defendant is. We're going to try this case once. Now, as far as the first question, whether defendant's presence is necessary, I think this court can resolve many of those concerns by holding non-critical hearings either virtually or hybrid with the defendant appearing from the jail. And this court under Rule 17.5 has the discretion as to what format a hearing will take, whether it will be in person or hybrid or completely virtual. Rule 17. The factors that this court looks at in Rule 17.5 in exercising that discretion favor holding virtual hearings for all non-critical hearings. And allowing the defendant to appear virtually, especially at those non-critical, non-evidentiary hearings, it doesn't implicate the defendant's right to be present. He can be present. He can communicate with his counsel face-to-face in real time and in confidence if necessary and do that all virtually. And I think the court could require that if his appearance on the screen is shown, that it not show that he's appearing from the jail, that he's not in custody in order to protect his presumption of innocence. Holding those kinds of hearings virtually also gets rid of this question about shackling. And it avoids the significant costs and risks, especially the risks to the defendant of transporting him here to court. I think it's interesting that in one of the cases that defense cites in support of his argument that the right to appear in civilian clothes and without restraints applies beyond the jury trial. State versus Luthi, the Washington case in 2024. There's a subsequent case in Washington, 2025 case, State versus Ferguson. That's 568p.3d314, where, in that case, even though in Luthi the Washington Supreme Court had said that requiring a defendant to appear in a holding cell that was adjacent to the courtroom violated the right to appear without restraints absent this individualized determination. In Ferguson, which was subsequent to Luthi, the court said that appearing by video from jail didn't implicate the right to be free from restraints. So, again, I think the first thing for the court to do is consider when does the defendant need to be present? And if he doesn't need to be present, then hold those hearings virtually. So that comes to the second question, which is, when the defendant appears in person, what kind of security measures are necessary? Does he need to be in civilian clothes? Does he need to be shackled? And I want to make it clear that at this point, the state agrees that in any proceedings before a jury, the defendant has the right to be in civilian clothes and unrestrained unless those restraints are justified based on a showing that the state would need to make. But defendant asks this court to extend those principles to non-jury proceedings. And there's no basis and there's no reason to do that. I just want to remind the court of the tenuous grounds that defendant's request rests on. Defendant doesn't cite any controlling Utah case law. What defendant relies on is a United States Supreme Court case that clearly does not apply to non-jury proceedings and then a vacated Ninth Circuit opinion. And as we point out in our response, the state points out, a vacated opinion isn't like an opinion that's been reversed on other grounds, where part of that opinion remains viable but the reverse part is not viable. When an opinion is vacated, it's vacated. It's like it didn't exist. Now, opposing counsel says that he reviewed the United States Supreme Court opinion that vacated that opinion and that it doesn't take issue with the reasoning of the Ninth Circuit opinion. And that's correct. But the reason for that, and this, Your Honors read enough appellate court opinions to know that when a court vacates an opinion either because it's moot, the case is moot, or because there's some other procedural defect that prevents the court from reaching the merits of the issue, the court's not going to comment on those on the merits. So it's completely unremarkable that the United States Supreme Court case that vacates the Ninth Circuit opinion, that it doesn't say anything about the reasoning there. I think it's interesting in point 5 of the defendant's reply that the defendant agrees with the state and the sheriff that these concerns could be resolved if the court prohibits the media from displaying pictures, photographs or video or otherwise displaying the defendant's appearance. I think defendant's willingness to agree to that position, assuming Your Honors willing to order that, resolves this motion. It allows the sheriff to provide whatever security measures he believes is necessary, clothing and shackling, without any possible prejudicial effect of those security measures on any prospective juror, because those images won't be being shown. Now, defendant says that shackling him somehow impairs his ability to consult with counsel, but I think just like today, if the defendant has the ability to be able to make a note to counsel, I don't see how, if the sheriff believes that those requirements are necessary, those restraints are necessary, how that could possibly interfere with his ability to participate in his defense and to consult with his counsel. I think any suggestion that this court might be prejudiced by seeing defendant in jail clothing or restrained it demeans this court and it ignores well-established precedent in Utah, primarily State versus Cravens and a host of other cases that talk about situations that might prejudice a jury do not have the same effect on the court. Knowing the defendant is in custody, knowing the defendant has prior convictions, hearing evidence that should not have been admitted, none of those situations have the same effect on a judge as it would on a jury. And I want to point out because I think defendant takes issue with this, but Cravens was not just a clothing case, a civilian clothing case. It points out in paragraph 4 of that opinion that the defendant appeared for his bench trial in shackles and in jail, in prison clothing. Now, the United States Supreme Court case doesn't change any of this because as I mentioned, that was about proceedings before a jury, not about proceedings in front of a judge or pretrial proceedings. That was a penalty phase proceeding that was in front of a jury in a capital case. And to the extent that the court, even though it's clear that doesn't apply here and that this court feels like it should nevertheless consider the rationale of that case, I think it's important that the court also consider the dissenting opinion in that case by Justices Scalia and Thomas, where they talk about and criticize those rationales, especially in non-jury, non-guilt phase proceedings, which is, again, I think all that we're talking about now because the state agrees that at his jury trial and even at the penalty phase, assuming that we get there, that the defendant should appear in civilian clothing and without restraints unless something changes to demonstrate that the defendant should be restrained in those proceedings. The dissent in Deck points out that that case is based on a very ancient common law rule that no longer exists, or at least the rationale for that rule no longer exists. The rationale for that rule was that when that rule was first developed, prisoners actually appeared in irons, heavy ponderous irons. They were painful. They rubbed the skin away and they wore them constantly in their cell even when they were sleeping. They wore them during trial. They wore them during a trial where they did not have the right to counsel, where they had to defend themselves literally, maybe not with their arms tied, chained behind their back, but with their arms restrained in irons. And the rationale for that rule was not so much that it affected the presumption of innocence, but rather it affected the defendant's ability to defend themselves when they're chained under those conditions and for that long of a period of time. The dissent in that case saw no basis for treating a defendant at a sentencing proceeding where he'd already been convicted. He lost the presumption of innocence, for treating that kind of a defendant the same as a defendant who's on trial and still retains the presumption of innocence. I think it's interesting also that the dissent talks about the rationale of courtroom dignity and decorum and debunks this notion that somehow shackling demeans those interests, somehow undermines the dignity of the court. Courtroom decorum and dignity is not a principle that creates affirmative rights for a defendant. Instead, it's a principle that limits a defendant's behavior in court. The court relies on those principles in order to make sure that the defendant behaves and that everyone in the courtroom behaves. It doesn't create affirmative rights. The Ninth Circuit opinion, Sanchez-Gomez, as I pointed out, that was vacated. That rationale doesn't apply in this case and shouldn't apply for those reasons. And the same for any court that has relied on that rationale for extending the right to appear in civilian clothes and without restraints beyond just the jury trial. And I think it's important that the court consider what defendant is asking the court to do. Again, there's no Utah case law that supports the kind of rule the defendant's asking for at pretrial proceedings. It's contrary to the practice of courts across this state. This court would be plowing entirely new ground and it would be setting precedent for trial courts throughout the state. And I think also this court should recognize that the rule that defendants asking for is contrary to the security plan for this court that the court's security administrator has developed. So even though other courts, non-Utah courts, have held that defendants can appear, or at least have the right to appear, without shackles and in civilian clothing outside of jury proceedings, the Utah Judicial Council has considered this issue. They've promulgated Rule 3-414-9(c), and it's true that rule leaves the ultimate decision about courtroom security up to this court, but it creates a presumption that all in-custody defendants should be restrained or supervised at all times. And again, I think it's important for this court to consider that the court's security administrator and the sheriff, who's responsible to provide security here, in their opinion, restraints should be required for all pretrial detainees. And it's important also to note that that Rule 3-414, it talks about cases of when there's significant publicity and, like this case. And that circumstance calls for more security, greater security, not less. And again, where defendant has suggested that he would be okay with not having any photographs of him in the courtroom, then I think that alleviates any concerns of having defendant appear in jail clothing and restraints, because the images won't be broadcast to the potential jury pool. Oh, let me also point out, as it was mentioned, it was suggested that it was defense counsel stated that it was the sheriff that released defendant's booking photo, and that's not accurate. The booking photo did come from the sheriff, but it was not the sheriff's office that released that to the media. That was a different law enforcement agency that did that. That wasn't the sheriff's doing. It was shared with that law enforcement agency under the government sharing provisions under GRAMA, and there wasn't any intent to try and get that out. In fact, when that was made public, the sheriff's office was very concerned that it had been made public. Unless the court has any further questions for me on these issues.
I do. What prejudice is there if Mr. Robinson appears in civilian clothing at proceedings to the state or to security?
I think as is pointed out in the security plan, and I think Mr. Van Noy can address this more particularly because this is the sheriff's domain. But the prejudice is that if there's anything that happens while defendant is in civilian clothing, then it's harder to identify him and be able to either neutralize a threat or protect him. If he's in civilian clothes, he's better identifiable in jail clothing.
And looking at this courtroom today, if he was in civilian clothing, is that a realistic threat?
Again, I think Mr. Van Noy can address this better.
I'll direct it to you, sir. I'm just trying to understand this line of thinking. And I appreciate you expounding upon it, and I appreciate the security protocols, which is being applied across the board, not to an individual. But I'm trying to apply it to this case. And it is unique. Whether we like it or not, this case is unique. And I think the shackles and the clothing are two separate issues. They're not, they can't be lumped together. But just going to the clothing issue, citing to security presence, which both sides have cited to, but to the clothing, I'm trying to understand the rationale about that because that's what I saw was one of the main issues, was being able to identify the person in custody as, and there will be potentially confusion if they're wearing civilian clothing. And I'm just trying to apply it to this scenario because this is what's in front of me and this is the decision. So I'm trying to gain that guidance and applying that logic to the case where we've noted there is significant security.
Which is exactly what Your Honor needs to do. I guess I would just add before I turn it over to Mr. Van Noy, that we're talking about hearings that will not be sealed, where there will be members of the public, potentially members of the media. This courtroom will be full with many more participants. And the issue will be having to identify defendant in that setting, not just in a setting like this.
And before we turn to you, sir, one question is we've talked about the prejudice and we've talked about in a jury trial setting, it's established that they're to be dressed in civilian clothing. However, the proposed solution theoretically proposed by both sides is if it's remotely transmitted, we don't run into this issue. Even if he's in court. But what stops a journalist from saying, Mr. Robinson appeared in jail clothing? Doesn't that create the same risk as a video?
I think Your Honor's order could stop that.
To suppress a journalist from writing?
I think from writing about a particular topic. Just like Your Honor can protect jury members' identities, prevent the press or anyone from identifying a juror, you could also say there's to be no comment, no pictures, no videos about the defendant's appearance.
But I'm sorry. Go ahead.
And if that's the case, then I guess I'm thinking what is, and there's not going to be anything broadcast about the defendant's appearance or communicated to the public, then why not just have him appear in jail clothing because it's not going to prejudice anyone in the court, any decision maker, any potential juror?
But even if I were to go down that route and say a blanket order that journalists, members of the press cannot comment about his clothing, every member of the public could be a blogger. Does that extend to them?
I think Your Honor controls what happens in this courtroom. And I think Your Honor could say there's to be no comment about the defendant's appearance.
Okay. And I appreciate your responses to that. Thank you.
Thank you, Your Honor. Mr. Ballard and Your Honor expressed and got it right with the general concerns the Sheriff's Office and Mr. Palmer have about civilian clothing. The specific concern about this case is that, in the filing documents, the state alleges that Mr. Robinson changed his clothing along the way. So specifically in this case, if he's in civilian clothing, that is, at least in the allegations, that is a real concern to the sheriff's office, that the clothing could be changed if there was commotion. We recognize that most pretrial proceedings, there's public law and motion calendars, there's other defendants and attorneys in here that create more commotion, not in the sense that it's undignified, but there's more people. So those are the sheriff's office's specific concerns about this case. I think going to the suggestion and I think agreement that no video or photographic reporting, the articles that the defense counsel cites in their motion, they hit on visual prejudice. When a person sees the individual in jail clothing, that creates the prejudice. I think there's a different effect from, based off of what they've provided, from seeing the individual as opposed to a reporter writing about it.
All right.
Did the court have more questions for the state?
It takes me a little bit for my brain to kind of go through all my tick points. So I'm still thinking.
I just don't want to interfere.
No. And I appreciate it.
I'm happy to answer your Honor's questions.
And I appreciate that, the willingness of both sides. I'm just trying to think if I'm looking at my notes. I've been trying to take detailed notes, and I appreciate the presentations by all parties. Going back to the clothing, and let's assume that this court orders no video, no cameras, and even goes even further and says to the press, you cannot write about clothing, and even if it extends to the weekend blogger or influencer or anyone, do not write about it. What stops prejudice to potential jurors? Because this is an open courtroom. What stops anyone? 75 people is what we've limited this courtroom for security reasons, from them talking to others and saying, you know, I was in court. He was in jail clothing? Does that prejudice the potential jury pool?
I don't think it does, Your Honor. This has been the practice. Every pretrial detainee in the state of Utah to date comes to trial, comes to the hearings in jail clothing and restraints. I don't know why this situation presents anything different than any of those other situations. And to the extent that there is some potential for prejudice, this court can fully explore that at voir dire.
Okay. All right. Thank you. I appreciate the responses. So Mr. Novak, and I don't mean to make this into a law school scenario, but why has no court found that this right of shackles investiture, how they're dressed, doesn't apply prior to jury? We've had this. I imagine that this has come up throughout the United States, throughout the years, but we don't have a single opinion that says prior to a jury trial that this should be in effect.
Well, we actually did have that opinion. I'll let you talk about that. We actually did have an opinion that addressed that, which is the vacated on other grounds opinion we've been talking about. So that actually was the prevailing law in the Ninth Circuit in 2017 and 2018, and there were district courts that applied that ruling, which applied to the Southern District of California, to other districts within the Ninth Circuit until, as counsel is right, the Supreme Court vacated it for the reasons that we've talked about. So I think it's more accurate to say that there was case law that governed the entire western corner of the United States, if I can talk about west of Utah, and Colorado for quite a period of time. Well, for a period of time until the Supreme Court vacated it on other grounds. I want to go back to the rationale. Okay? And so I think what's important, and unfortunately it falls on this court's lap, so to speak, is this is an open question in Utah. That's where we are. We're in the trial court, and it's an open question. There isn't a binding authority one way or the other on this court. We are suggesting that existing law and the rationale in existing law and rationale expressed by well-considered jurists in other jurisdictions guide this court in what it should do. But that's just where we are. I cannot really give the court the law school answer, which is, why don't we have case law on this from this jurisdiction or others? Maybe it's because nobody raised it. Maybe it's because not every defendant is actually shackled in court. I mean, I'm just going to testify. Okay? I've been in many courts in many jurisdictions, and with clients who are in custody, and sometimes they're shackled and sometimes they're not. It depends on local practices. It also depends on what the judicial officer standards are. So I don't think it's that everybody is shackled everywhere, and now all of a sudden Mr. Robinson is bringing up something that's settled practice otherwise. It's an open question that the court has the opportunity to wrestle with. I'm not trying to avoid the court's question. I just think that's the reality, is that it is an issue of first impression since DEC in Utah.
And I appreciate your candor, sir. The second question I have is applying the individualized approach and basically determining security risk or potential is in the criminal court. As you are well aware, issues can turn on the moment. And, for example, hypothetically, in a preliminary hearing, a witness could testify to something that could cause someone who's in custody to suddenly have a surge of emotion. And how can we account for that when there are so many variables in a courtroom that we cannot control? How someone reacts to a statement, how someone reacts to a shout out from the crowd, how someone reacts from a glance that may cause them to react emotionally. How can we apply that in real time if we're relying upon an assessment that has to be done before a hearing?
I think it's a fair question, and I have two answers that may or may not be sufficient for the court. One is I think it can be an evolving understanding of how the defendant, before the court does handle themselves in the courtroom. Okay. So far, we've got a couple hours of experience. I don't think that the court, if it's an individualized determination, which is what DEC says, that's still good law, then that individualized determination of course can always be subject to reconsideration by the court. I am sure that Your Honor has been involved in a situation where somebody, who was not even in custody, but was appearing in their own criminal case, became a problem in the courtroom. And similarly, you could have somebody, who maybe was a problem, and is in custody, but over time has demonstrated that they should not be. So I think that the individualized determination can be one subject to, I don't mean reconsideration in the technical legal sense, but review. So that's one thing. The other thing is that the court can look at the information it has before it. So I'm going to provide what I think is responsive to this court's question by pointing out that even with the state having the opportunity to stand here, they still haven't provided any individualized information at all. I invited it multiple times. There's nothing individualized that has been represented by the state whether we accepted the proffer or not. What we do know about Mr. Robinson that goes to the court's question is he surrendered. A neighbor of his. I'm sure the court has read enough of the materials. I think it's even in the probable cause statement. You don't even have to read the public accounting. A neighbor of his was a retired sheriff from Washington County, and he got in that man's car, and they took him to the sheriff's department with his parents in the vehicle with him. That, if you were just doing sort of a run-of-the-mill bail assessment, would be a factor in support of release. A factor. Okay. So what information does the court have to say that if somebody was testifying in a preliminary hearing who said something that Mr. Robinson felt uncomfortable with, that he would react in a way that placed somebody at risk? And with all due respect, it's total speculation, because you're talking about somebody who surrendered. Okay. I'm happy to engage in this colloquy. I wanted to say a few things about what the people said.
Of course. Go ahead.
Your Honor's questions are more important than my retort.
No. And I appreciate, and I know it's a difficult question because there's so many variables. I guess the other factor I wish to touch on is, and this is not speaking to Mr. Robinson. This is speaking to all criminal cases. As criminal cases proceed, and I don't know how this case is going to proceed. It could last a week, it could last a year, it could last, who knows. But I believe it's the experience of all attorneys in the criminal world that as cases progress, pressure progresses. And in a case with a potential death penalty, and, again, not referring to Mr. Robinson, but the psychological effect on a person as they go down the track puts in a variable that's hard to examine in real time. And how do we address for that? If we were even to go down that route. I don't know about this case. But you have that experience. What insight can you provide?
I've never, so I've been a criminal defense attorney since, I don't know. I can't remember how long. It's been a long time. I can't think of any client who's ever attempted to harm me or myself, me or himself or herself, or a law enforcement officer in a courtroom, or tried to flee a courtroom, or lash out at a witness, or throw something in the courtroom. I of course have heard about such things. And usually, because of my own experience, it's somebody who spent decades in prison, and now they're being prosecuted for something they did in prison, and they got nothing to lose. That's the best I can do.
Thank you.
Okay. A couple things if I may about Rule 17.5. I think the 14th Amendment says that Mr. Robinson has a right to be present at all of his proceedings. And I hope I don't say this too many times, but I'm from another state, and most of my time practicing in that other state has been in federal court. And with respect to the notion of hybrid hearings and remote hearings, the pandemic is over. I understand it's convenient for the sheriff. I understand it saves government money. But this is a capital case, and Mr. Robinson wants to be present at every hearing in person. If he's not present at every hearing in person, then he's either appearing remotely in a place in the sheriff's jail facility where there are staff present with him. He's not in a room by himself. And then, that would mean that maybe one of his attorneys could be over there. But that attorney wouldn't be able to consult with other attorneys I just think it is a shortcut which this court should not engage in this type of a case. Mr. Robinson is not going to waive his appearance for hearings in order to eliminate the need for him to assert his right not to be shackled. Okay. That's not a voluntary waiver. If the court, as it has, which has been fine with us, wants to convene a hearing on short notice, the court says, hey, I need to get everybody on the telephone. And we do that. But from our standpoint, that's appropriate for the administration of justice. But when we're having meaningful hearings, and I'm not going to use the word critical in a legal sense, Mr. Robinson wants to be in court in person so that Your Honor and he are in the same room, so that he knows what's going on, so that you can fully observe him, so that he can fully observe witnesses. So it's not an accommodation that interests us, respectfully. The question about jail clothing, which Your Honor asked, I would ask the court to consider the cases we cite at page 13 of our reply brief. They are Mitchell, which is a Utah decision, Estelle, which is a Supreme Court decision, and Hernandez versus Beto, which is a Fifth Circuit decision, which basically all say that there is no essential state interest in compelling somebody to wear jail clothing. The idea that because Mr. Robinson maybe changed clothes before or after the charged shooting has nothing to do with whether Mr. Robinson sitting there in a sweater and blue jeans or whatever the sheriff and Mr. Robinson's counsel agree is appropriate clothing could somehow turn into Superman, by spinning around in a circle, it's just not going to happen. And I have no problem with it, but there have been redacted. So I think what Your Honor is saying is like, why does he need to be in prison garb when we have all the security in the courtroom generally speaking? Is the right, if I may, the right question. And if things happen in the courtroom which suggests to the court that it has made an assumption that Mr. Robinson demonstrated it shouldn't have made, then the court can make restrictions. I do want to say something about just like presumptions and language. Sure, we can have a statewide or district-wide policy. That doesn't create presumptions. The Constitution is what controls where the presumptions are. And it's the people's burden. It's the state's burden to interfere with a constitutional right. The policy doesn't create a presumption that we have to rebut. The policy is what the sheriff and the court security specialist would like. It's not a presumption. It may be guidance for this court once the court completes its individualized determination. I think the last thing I want to say, and I'm sure that will make everybody happy, is that it is not correct that defendants charged with very serious offenses who are in custody always appear in shackles and in jail clothing. Ms. Nesser has pointed out to me twice in the last 15 minutes, And I appreciate it because I forget things, that she actually represents a defendant who is in custody, who is charged with first-degree murder in another state, another county, who sits in court without shackles, and who wears street clothing. Because a judicial officer made an individualized determination that that was okay. If I've left something out, please tell me. Submit it.
All right. And is there anything further from either side that you wish for me to consider? And before I go there, I also want to clarify that my understanding is I'm not ruling about the media. I'm not ruling about which hearings he should or should not be able to attend. My understanding is that's going to be further briefed. And so I want to be clear that even though it is, there is this attachment, that's not the expectation of my ruling on Monday. I'm ruling on the issue of striking the motion, which is obviously the easier of the motions, and in regards to how he is dressed and whether he is restrained, is my focus. Even though I've heard from both sides about other issues, I want that to be more fully briefed even though it does touch upon that. And it sounds like we may have the time if we continue the 30th hearing, so that issue is not immediately upon us. But with that, I want to open it up to either side. Any other information or argument you want me to consider as it relates to those three issues?
Well, I think Your Honor raises a good point in that if we're going to have further briefing on an issue that talks about potential limitations on what the media can cover, and if that ruling is going to bear directly on the ruling on the motion today, then I think maybe, and we're not going to have that hearing on the 30th, then maybe the court delay its ruling on this motion until it has the fully briefed motion about what the media can do.
If I may, that reminds me that I did forget something, but my co-counsel wouldn't know it because I didn't share it. The suggestion that this court can order the entire world not to say anything about what Mr. Robinson is wearing in court is both impractical. I think it's a prior restraint, and the burden would fall on us to enforce it. I mean, that's asked with a question mark at the end. It's completely unenforceable. The idea of prohibiting cameras and video in the courtroom is very easy for this court to enforce. That's easy. What people can say outside the courtroom, even if it is constitutional, I understand that it is very common for courts to order the media not to comment upon what jurors, what they look like, information they provide in voir dire, like all kinds of limitations, but to somehow believe that this court can effectively prohibit every blogger in the world from commenting on what Mr. Robinson is wearing in court, it's totally unenforceable. And I actually don't think anybody's going to enforce it other than the defense, and that would be completely impractical. I mean, our effort to keep track of who is saying what about our client is already, an insane project. And I also don't think that if this court were to eliminate cameras and video in the courtroom, which I know we haven't fully briefed at all, doesn't go to the shackling issue, because the shackling issue is about other constitutional rights than just the first concern, which is the visual appearance of somebody in shackles suggests that they are guilty of something. Because the other two interests are the decorum in the courtroom, the sanctity of the courtroom, and the Sixth Amendment right to be free from shackles in order to participate with your counsel. So I don't think that banning video depictions from the courtroom addresses the shackling issue at all.
All right.
If I could just add, Your Honor. Your Honor has a difficult decision to make. Really what it comes down to is a weighing, right? A balancing of defendants' right to a presumption of innocence and a fair trial and security. And at trial, there's no question that the right to a fair trial and to the presumption of innocence. When you're in front of the jury, there's no question that that balance tips in favor of what defendants requesting. At pretrial hearings, the calculus is completely different. And even with the media, and even if this court is uncomfortable with an order saying, don't talk about, don't write, don't state the way the defendant appeared in court, I think a description of the way defendant appeared has far less potential prejudicial impact than a photo, which I think the court could restrict, a photo or a video. Just two other issues, Your Honor, to briefly mention. Defendants repeatedly made the point that the state hasn't provided any individualized information about the defendant. The state hasn't done that at this point because there's no requirement for the state to do so. Until this court finds that it's going to plow completely new ground and extend the rights that defendants asking for beyond the jury process, then there's no need for the state to provide that information. And as far as the right to be present, a defendant is guaranteed the right to be present. This is from State v. Maestas, a Utah Supreme Court opinion that's cited in both of all of the briefing, or from both sides. A defendant is guaranteed the right to be present at any stage of the criminal proceedings that is critical to its outcome if his presence would contribute to the fairness of the procedure. And it's the state's position that the defendant certainly would be entitled to be present in the courtroom with his counsel during those kinds of proceedings. But in others, he does not need to be in the courtroom. He can still be present, but he can be present virtually where he can communicate in real time and confidentially if necessary. And just one final point, Your Honor. It sounded to me like defense counsel was saying that if he were in civilian clothing, redacted. I'm curious if that's accurate, but that might be one way to further balance interests.
Thank you. And just to clarify, I don't mean to repeat myself, because we are coming to the end. I am not making a ruling on what hearings he can or cannot be on. That, I'm assuming, both sides is requesting more briefing on. I'm simply limiting it to the motion to strike the filing of the state, the clothing issue, and the restraints. I don't want there to be any miscommunication or expectation. Are we all on the same page?
We are asking leave of the court to more fully address what we thought, which we addressed very, very quickly, which we thought was a motion under 17.5 to limit Mr. Robinson's appearances. We want to address that more fully. So, for example, in the state's paper, they address the 11 factors that a court should consider under 17.5. I didn't want to take that up today given the timing, but yeah, we want to address that more fully, and we will. And we can work it out with the state whether we file simultaneous briefs, or reply and surreply, or whatever we call it. They're saying they didn't file a motion. We thought they filed a motion, so we filed an opposition to nothing. We'll get the court points and authorities from both sides.
Thank you. I just want to clarify that. All right. So it sounds like with that expectation, and does Monday at 1 o'clock on WebEx work for all parties?
Yes, sir.
And because we are in a sealed proceeding, I want to address an issue that goes to the very heart of what we're dealing with. It seems to me that because we're addressing the issue of Mr. Robinson's dress and restraints and because that ruling will be public and will be streamed, it seems, to protect the interest of Mr. Robinson, his constitutional rights, first of all, he should be able to participate, but it seems counterproductive if his camera was on, because it would defeat the whole purpose of why we're here. How do all parties feel? I'm not saying that's what should happen. I'm saying I want your input so we're all in agreement come Monday at 1 o'clock. I don't.
We are agreeing to a WebEx hearing as the court proposed, which would mean that for the court to issue its ruling, right? The court's not entertaining more arguments. The court is issuing a public ruling on documents that were mostly publicly filed. And then, there was appropriately sealed argument. We are okay for purposes of receiving the court's ruling with Mr. Robinson appearing from the jail, audio only, for the same reason we did last time, and for the reason that the court just stated.
All right. And I just wanted to check. Because I don't want us to get there and someone has an issue. Because this kind of goes to the heart of what we're dealing with today, and I don't want to.
Yeah.
Go, okay. Thank you. I think we're all on the same page.
I think that's the perfect procedure, Your Honor.
All right. So we have that Monday at 1 o'clock via WebEx. In regards to, are we in agreement to strike the 30th, the hearing on the 30th?
Yes. And our suggestion, if we may, is that the court give us a date that's convenient to the court in early January. We, I think, can work out amongst ourselves a schedule for sort of briefing all of that stuff with the understanding that we will file our motions before Thanksgiving. And the parties have committed to working through the responsive pleadings in December. We just would like the court to tell us while we're all here with our calendars what works in January.
All right. Let's pull up a date. But while we're going there, one of the purposes of the 30th's hearing is I wanted to get an update on the discovery because that's going to guide where we go. And I just wanted to check the pulse of both sides to see where we're at, to see, are we on track? And the state had indicated they wish to be setting a preliminary hearing. So while we have that time, and I'm fine with that, I think it's appropriate. I want that time to be well used to ensure that we don't come back the 30th and say, oh, Your Honor, there was this issue of discovery. Now we're back another 60, 90 days. And so that was one of the purposes of the 30th's hearing. And I want us to have an ability to address that in a timely basis for Mr. Robinson's speedy rights and for alleged victims' rights of dispositions as well as in the interest of justice. And so, and I know it's late, but I want to touch on that to see where we're at, if we have any issues that we can quickly address or if we just need another hearing. And so I wanted to keep us on track for everyone's benefit.
Chad Grunender for the state, Your Honor. I can provide an update for the court. And defense counsel and the state, we met before this hearing and talked about this. First of all, our offices are working together. Our paralegals are in constant communication about sending and receiving discovery. We have to date, as of this afternoon, received in the range of about 4,085 files from law enforcement. We received about 1,700 of those within the last probably 12 hours. There's a process that our office is going through and making the necessary redactions per statute, per the law, and then we're moving that to the defense as quickly as possible. We have provided 1,442 files to the defense thus far, so it's about 35% of what we have in hand right now. Every week, at least once a week, we provide a batch of information to the defense. There have been a couple of hiccups because of the size of the files and the system we're using that we're working through. I think we're getting to the bottom of that, and we'll continue to work through that when issues arise. We're also identifying the dates when the information is received and trying to push that out chronologically to the defense as quickly as possible as well. This case involves a lot of surveillance camera from UView, and we're starting with September 10th being the most probative, most important day, and then working backward from that. So we're trying to prioritize our efforts as well. So I think we're making progress there. And I think we're going to iron out a few kinks, and the progress will be expedited as we move forward.
All right. And from defense, Mr. Grunder, did you have anything else? I didn't mean to cut you off. Okay. From defense, any thoughts? Progress or things that you wish to bring up with the court?
Everything that was just stated accurately represents the collaboration, and it also presents a picture of the amount of material we need to get through. So far.
Right. Right. And my final question, and I appreciate it. I think when there's good cooperation between the parties, that is in the interest of justice, and it just makes the process go so much better even though it is an adversarial system.
We have no discovery disputes given the way things have gone. There will of course be requests that we may have based on what we see in the discovery, but we're not there yet.
And I'm not holding anyone to this, but I'm trying to earmark time for a potential preliminary hearing. And whatever you say is not something I'm holding you to, but do we have a very basic idea of how much time the court should be allocating for a potential preliminary hearing? And again, I don't mean to put you on the spot. You are not prepared for this. I'm just trying to see, how much time theoretically should I be looking at? Because I want to get that available and have that in mind.
Very fair question, Your Honor. And we're trying to come up with that as well. And as we sit here today, in my experience, I've done preliminary hearings that last 10 minutes to 5 days. This will be probably more complex than a typical homicide case, but I would ask the court for at least 5 days. Understanding it's a probable cause hearing as well. As much as we want to get in to do it, to litigate every issue, it's a probable cause hearing. So I would say 5 days as I stand here today.
Okay.
And then I just had one more issue to bring up after we...
Sure. And again, I'm not trying to put you in a corner or in a box. Any thoughts? And if not, that's okay. Because...
I don't think we can really comment on how long the preliminary hearing would be at this point. I think the state has a better sense of what kind of a case it wants to present. Obviously there's cross-examination. You know?
All right. Okay. Thank you, Mr. Grunder.
There's one outstanding issue, and that's the preservation order, and there's some pending filings with respect to that. And I know we're going to talk about an early January date to convene next, but there might be a need to meet before then. And the reason I say that, if an issue comes up, again, we don't want to violate any orders. We want to act appropriately. But there's still additional testing that's being done, forensic testing with respect to evidence. So we're going to cooperate with the defense on that, but there may be a need of some time to reconvene with respect to that issue. Because, again, we want to investigate this as expeditiously as possible and move the information to the defense in the same fashion.
And I want the parties to know if an issue does come up, this court will prioritize to make sure that we have that time to act quickly, because it's in the interest of all parties and in the interest of justice. So I will make that a priority. And I realize things can come up that we don't even know about, which they will. And that's okay. All right. What potential dates do we have in January? And how much time do we need, is probably an important question. That's going to dictate.
I think we outlined a number of motions. A different way to do it would be, depending upon the court's own calendar, is to do 2. I don't want to say 2 half days, because I don't want to say it's, 8 hours of argument. But there's a few motions there. Right? So maybe, I don't know how the court's calendar works. I'm just thinking, that's one way to think about it, is if there are 2 days where the court has time, we can knock out some on one day and some on the other. But maybe the court prefers to just use a clear day and go from start to finish. I have no idea how the court.
Assuming the court has a clear day.
2 partial days back-to-back eliminates, well, at least travel for some of us.
All right. So potentially 2 4-hour blocks, and then we can figure out what we argue on which days, whatever is effective or works for the parties.
Your Honor, if I could ask respectfully, that is the month before I have a fairly large homicide trial starting, and so we have cleared several days for evidentiary hearings on our last round of motions. So that week of January 5th, if we could avoid that week and maybe look at the next week of the 12th, just because I've got 3 days of hearings that week of the 5th in my other case.
The court discusses dates and scheduling for a few minutes.
All right. And obviously we'll address who needs to be, there's issues we'll address, but these hearings, unless there is mention of it needing to be a closed hearing, the assumption is they will be open hearings unless the parties bring compelling reasons to close them.
There may be aspects of the hearing on the motion to disqualify, which, out of respect for the privacy of the family of a member of the state prosecution team, should be sealed, because it would necessarily reveal family relationships and names, and where somebody goes to school or, I don't want to say too much, although, we're in a sealed hearing. We're sensitive to that. And we're actually going to file that motion and request that it be filed privately, so it's not a public document, but so the court has the specifics.
I think that's fair. And counsel has given us a heads up with respect to that issue, and we'll see how we respond. There may be interest and a need for the court and for the record to have a response as far as the identity or to some degree the identity, but we'll cross that bridge when we get there.
I definitely don't want I don't want the family member getting the emails that I'm getting right now, so we're going to try to protect that innocent family member from experiencing that.
All right. So just for the benefit of that being a potential issue, can we address that on the 16th? And if there's any other potential issues that needs to be sealed, let's kind of group them together so we don't have to seal both of them. That can affect transparency. And so let's say the 16th theoretically is sealed.
Honestly, Your Honor, we may only just need to just have everybody leave and seal a portion of the hearing, just a few minutes where we enter into the record the part that we're trying to protect, the person we're protecting.
Okay. I appreciate that.
So I don't even think we would need to seal the entire hearing, just where if you need to know the details about the individual, and if the prosecution would like that to remain private.
All right. So we'll earmark the 16th potentially for partial seal.
I just want to add I think we can file these in such a way that we have a public document and a protected document. The public one would be redacted. And so, because I think that's what I would prefer to do so that we can argue these. And then we'll just provide the court with both a public and a redacted one.
All right. And it sounds like there's good communication between the parties. Unless the parties are requesting filing motion dates, I'm happy to leave it to you since it's still kind of up in the air. It sounds like we now know the dates and so we can work toward those dates, allowing the opposing party time to respond. We're all well established in what time that takes, and so I'll leave it to you unless there's a request otherwise. All right. And counsel, in closing, I want to comment on the professionalism and the civility all sides have shown. I recognize that this is a very difficult matter for all parties. And I wish to comment that your professionalism, your civility, and the way that I see that you are working together is very commendable. So, thank you.
Thank you,
Your Honor.
And with that, I wish you a good weekend, and this court is in recess.